Welcome to Spilling Secrets, a podcast on the future of trade secret and non-compete law. My name is Pete Steinmeyer. I'm the managing shareholder of Epstein Becker Green's Chicago office and one of the co-chairs of EBG's Trade Secrets and Non-Competes sub-practice. I will be one of the podcasters on this program, and we thought that we would take some time to tell you a little bit about the four of us who will be doing the podcast, how we each got into trade secret and non-compete law, and what we plan this podcast to be. So with that, let me tell you a little bit about me. I first encountered non-compete when I was in college, and I had to sign a non-compete in order to get a summer job as a house painter. Now, at the time, I knew nothing about legitimate protectable interests or any of the topics we'll be talking about on this program, but I did sort of instinctively know that it was ridiculous that an 18-year-old kid had to sign a non-compete in order to get a summer job as a house painter. Of course, I nevertheless signed the agreement and started my career as a summer house painter. After retiring the paintbrushes, I went off to law school, clerked for a federal judge, and eventually became a labor employment lawyer here at Epstein Becker Green. Over time, I began doing more and more work regarding non-competes and trade secrets, and today I spend about 2/3 of my practice on non-compete and trade secret matters. I never set out to be a non-competes lawyer. It just sort of happened. I thought the issues were very interesting. I liked the fast pace, and I liked the fact that I could litigate on both sides of these cases, because one day my clients were hiring from a competitor, and the very next, they were chasing someone for jumping ship to a competitor. I also like the strategic angle to these cases. How can you draft an agreement that will actually get enforced by a judge? How do you do that if your employees are all over the country? And how can you hire a star employee from a direct competitor and minimize the risk of getting sued? These are the types of practical real-life problems that we will be talking about on this podcast. Real-life talk from real-life practitioners, including one former house painter. With that, let me turn it over to my EBG colleagues and fellow podcasters so that they can each introduce themselves and tell you a bit about their own journeys to this podcast. Kate Rigby, joining us from Boston, Massachusetts, the home of America's original and still all-time favorite podcast, Car Talk. You're next.
Thanks, Pete. I can't promise to deliver an amazing Boston accent like the guys on Car Talk, but I probably should have been a guest on the show or a caller into the show based on the lackluster performance of my cars over the years, which I'll save for another time. As Pete mentioned, I'm in EBG's Boston office, and I joined the firm in August of 2021. Before that, I spent over 15 years practicing in an international employment law firm, focusing on all areas of employment counseling and litigation. I actually started my career in Charlotte, North Carolina, and then moved to Boston in 2009. And like Pete, my first experience with non-competes and other restrictive covenants occurred before my legal career. And in my case, when I was working in recruiting and human resource management positions. As a recruiter, I had to explain restrictive covenants that were in the contractors' employment agreements as part of their onboarding process. As a lawyer, I began reviewing and revising non-compete agreements early on. And by around my third year of practice, I assisted in my first non-compete dispute in North Carolina. And then over time, partners asked me to work on more and more non-compete matters, probably in part because I was the first associate they ran into in the hallway when they were looking for assistance. And also because I was willing to, stay up late to work on those emergency motions and other pleadings. So I have a lot of vivid memories of working around the clock on those, including one time when I was about 7 or 8 months pregnant and was up until about midnight reviewing and revising affidavits and on the phone with a client. So by the time of the hearing, I'm sure I was pretty feisty, and that probably led others to thinking that I had the right personality for these type of disputes. But these days, I really love to assist clients in thinking through how they want to structure their restrictive covenants based on the needs and location of their business, their employee population, and their risk tolerance. And I also enjoy the investigative work involved with potential misappropriation matters and assessing whether it's necessary to litigate a dispute. So with that, I'll hand it over to my newest partner in crime here in Boston, Erik Weibust.
Thanks, Kate, and thanks, Pete. As the newest member of the EBG team, having only joined about 3 months ago, I'm really excited to be at the firm and to be part of this podcast. I think this is going to be a lot of fun. So Pete and I actually met a year or so ago on another non-compete podcast series that a mutual friend of ours invited us both to take part in. Unbeknownst to me at the time, it was that introduction and getting to know Pete over that year through that process that would ultimately lead me to join EBG about a year later. I'd also known Kate through various bar events in Boston for many years. And when I found out that she had joined the Boston office of EBG and she and I talked about why she moved and her experience, that really sealed the deal for me in terms of coming over and making the move. Like Pete, I also started my legal career clerking for a federal judge. In my case, it was Judge Peter Hall of the United States Court of Appeals for the Second Circuit. And like Kate and Millie as well, I spent the first 15 years of my career in private practice at a very large international law firm where I focused the majority of my time on trade secret and non-compete litigation and counseling. Unlike the others on this podcast, I'm not a traditional employment lawyer. My prior firm housed the trade secret and non-compete group in its litigation department. So I come at these cases from a slightly different perspective. And in fact, a big portion of my practice is commercial litigation still. So my road to becoming a trade secret and non-compete lawyer is not nearly as interesting as Pete's or Kate's. When the Massachusetts legislature first started contemplating non-compete legislation in 2009 or so, I was asked by a partner at my then firm to speak with her at a firm-sponsored breakfast briefing on the topic. I didn't know anything about the area of law. I'd never worked on a case or researched the issues. And I remember having to look up the very basic elements of a non-compete claim and the very basic requirements for enforcing a non-compete. I'm sure I left a lot to be desired at that briefing, but it planted a seed in me. And after that, I began getting staffed on more and more trade secret and non-compete cases, and I really fell in love with the area of law. I love the human component. I love the fast pace. I love that the facts are always very unique. I love that every state's law is a little bit, or in some cases, very different. And I love the fact that there's typically no black and white answer to just about anything in this area of law. It's all about risk management and risk tolerance and working with clients to come up with creative solutions and creative legal arguments based on the facts before us. And I love that as well. One of my favorite things to do in practicing law is to defend employees in these types of non-compete cases. I really feel like I'm helping someone get out of a jam, and they're always so grateful throughout the process, especially, of course, when we obtain a good result. Working with individuals whose lives will be affected by being put out of work, even if just for a few months, also gives me a very helpful perspective for when I'm representing companies that are considering suing a former employee for breaching a restrictive covenant. As Pete mentioned, we represent clients on both sides of these cases. I try to humanize the situation as best as I can for the client. And if there's a real threat to my client's legitimate business interests, then obviously we'll file a lawsuit and litigate aggressively. In fact, I'd love to do that as well. But often there's always ways to resolve a dispute short of litigation. And I try to keep the human aspect and real life consequences in mind in all of my cases. So I look forward to talking through these issues with the three of you, Pete, Kate, and Millie. Now let me hand it over to Millie Warner for her to tell us a little bit about herself.
Thank you, Erik, and thank you, Pete and Kate. I joined EBG in February 2021. And before that, I had practiced for almost 15 years at an international firm focusing on all types of employment litigation. I actually started my career practicing in Boston, and I've also spent about 2 years practicing in London. But I have spent the majority of my career practicing here in New York, which is where I am now with EBG. I stumbled into the trade secret and restrictive covenants area pretty early on in my career when I was a junior associate, and I got the dreaded late Friday afternoon call from the assignment partner in my group, except that this wasn't just any Friday afternoon. It was the Friday afternoon headed into the Memorial Day weekend. But I took the call, as I had to, and I was told that there was a time-sensitive matter that I needed to jump on straight away. Basically, there was an employee going to a competitor, and we needed to draft a complaint and TRO motion, all the various supporting papers over the weekend, and be prepared to file first thing on Tuesday, the day after Memorial Day. All the various supporting papers over the weekend, and be prepared to file first thing on Tuesday, the day after Memorial Day. So needless to say, that was a frantic holiday weekend, and I will always remember Memorial Day 2007 as my baptism by fire into the world of non-compete litigation. But I stuck with it. And since then, I will say I've noticed a pattern where these types of cases do have this uncanny tendency to come up over holidays, to the point where that's almost how I mark them in my mind. There's the the one that happened over Thanksgiving. There's the one from Christmas, President's Day weekend, of course, Memorial Day weekend, et cetera, et cetera. I think I probably have all the major holidays covered at this point. Notwithstanding their tendency to disrupt holiday plans, I was really instantly drawn to this area once I experienced it. Just the fast pace, the investigation, putting all the factual puzzle pieces together, and just being totally immersed in one thing. Because once these cases start, they are really all consuming. It's just a fascinating area and actually really a lot of fun to practice in. So I'm really excited to be part of this podcast and to talk about all these issues with the three of you. With that, I'll hand it back over to Pete.
Well, thanks, Kate, Erik, and Millie. And Millie, all I can say is that I hope Memorial Day 2022 was calmer than Memorial Day 2007. But I look forward to our conversations about the future of non-compete and trade secret law. A special thank you to our listeners for joining us. If you would like to subscribe to the show, for free, of course, please go to ebglaw.com/subscribe/ and click the box for Trade Secrets and Non-Competes / Spilling Secrets podcast series. Until our next episode, this is Pete Steinmeyer signing off on behalf of the Spilling Secrets team.
The Employment Law This Week and Diagnosing Healthcare podcasts are presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of the legal services to be performed is greater than the quality of legal services performed by other lawyers.